From the News Channel 5 Network, this is OpenLine.
Good evening and welcome to Ask the Attorney. I'm your host, Amy Rao Mohan. On Ask the Attorney, it's your chance to ask any type of legal question you have. And tonight, our guest is Kevin Kennedy from the Kennedy Law Firm in Clarksville.
Amy, good to be with you as always.
Good to be with you too. And really, this is a show that we were just talking about. It's a lot of fun. We really enjoy it because people call in, ask all types of questions, whether you've got a civil case, criminal, wills, property,
bankruptcy, whatever it is, car wreck. It's fun and we love to share. And you know, it's kind of like so many people need this knowledge. We have it. We can give it away, and it's win-win for everyone. And quite frankly, you do a great job. I was telling you earlier in the studio that people stop me all. I love to watch your show, and they like Amy, and so I salute you for that, Amy, and the viewing audience. And
well, thank you.
Feel free to call in. Any questions? There's no question that is stupid because lawyers all the time ask questions, and we get many different answers. So call in anytime.
Right, and call in that number at the bottom of your screen at 737-7587. And while we're waiting for some of those calls, Kevin, tell us a little bit about your practice and what you do.
Well, you know, at the Kennedy Law Firm, we're in Clarksville, have 3 different locations. I've been in the practice of law now 32 years, and I say, you know, what do you learn? You need a group. I always like a group of lawyers, and I always like to say this, Kevin, if you needed a lawyer, what kind of lawyer would you look for? And I'd look for one that's experienced. I'd look for one in a group. I'd look for one I could identify with. The most important thing is I'd look for a lawyer I could trust. And, you know, an honest one, you know, an honest lawyer, the only thing he could do is make an honest mistake, and then he would do everything in his power to try to correct it. Now, we do lots of car wrecks at the law firm, and I have people ask me all the time, well, what do you look at? Why would you hire this firm instead of another firm? Great question. And one of the things I'd look at is, do they have the resources necessary to prepare the case? And you know, the last $5 million settlement that we had, it was in excess of $200,000 that we had to invest in experts. So, you know, most lawyers don't have those kind of resources available to them.
And what kind of case was that?
Those were death cases. Okay. And so you have to have experts in those cases to say that the cause of death was caused by the negligence of the one we were bringing the case. And of course, once you bring those cases, when you're talking about a $5 million settlement, how good are the lawyers on the other side? How good are those insurance? They're the best. They're the cream of the crop. And you say, well, okay, what about these they've got a team of They have a team of lawyers. And in fact, in those depositions, we had as many as 16 lawyers.
Wow.
And so, you know, it's a nightmare to schedule, and everybody has their. But ultimately, it was great for the client. So I want somebody you can trust. I want somebody who has the resources, because if your lawyer has a crisis, who's there to pick up if he's hurt in a car wreck? And that's one of the reasons, you know, at the Kennedy Law Firm where we had so many lawyers, because when you need an army, that costs a bunch to feed an army, but when you need the army, you need the army, and you can't go out and rally the army because you have to have them in a split second. So I think those are 2 of the things. What's their reputation? Is it a reputation that they've had many big settlements? Hey, I want to hear it. And you can sit down and talk to them. They probably won't mislead you. And most lawyers have never had $1 million settlement. And so, and there's a reason because of that, because people haven't invested in them. They haven't attracted the big cases, things like that.
Right, and we'll put Kevin's information up on the screen after the show, but please call in and Kevin will give you all the advice that he can on any type of legal question. Again, that number is 615-737-PLUS, 737-7587. Let's start taking some of these calls here.
Yeah, you're lit up.
Marilyn. Hi, Marilyn.
Hi, how you doing?
Good. How can we help you tonight?
Okay, I have a scenario I want to get the information on. Say if I own a house that's only in my name, and my boyfriend wanted to have an in-ground pool put in the backyard of my property. His name is not on the mortgage.
Yes.
If something were to happen between me and him, and he walks away and doesn't want to finish paying for it, am I going to be responsible to finish paying for that?
Okay. Basically, when they put that, it becomes a part of your real estate. So he's got a real problem if they put that pool in. Never say never. There's always some exceptions to the exception. Of course, the pool people really ought to find out who owns that land before they put that pool in. But there is a theory that they could go out and place a lien, a materialman's lien on that property that they were never paid for. Of course, again, you'd have to get a good lawyer. A good understanding keeps down a misunderstanding. There's also a law that says you can't be unjustly enriched. Now, if he maintains, I loaned the money to her to put this in there, that's his problem. He'll have to provide the statute of frauds. There's got to be a writing. If you said it was an inter vivos gift, he put it in, and he knew that there was no strings attached, then that was my gift that I received. There's always some gray areas. I like to have a real good understanding. I like to make sure he's got the money to put that in there, because you never know what could have come down the road.
Yeah, and smart to think about it beforehand.
Excellent. You did good. I'm glad you identified that as a potential issue.
All right, we've got Jeff who's waiting here. Hi, Jeff.
Hello?
Jeff?
Yeah,
Yes.
go ahead, Jeff.
Yes, thank you for taking my call. A little bit nervous. This is the first time calling.
No.
I'm calling on behalf of a friend of an eviction situation.
All right.
I was under the impression that if someone's to be evicted, they have to have that letter within 10 days, and then they have to go before a magistrate, and the judge has to make a ruling as to whether or not that person has to be convicted. Is
Okay.
that true?
Here, the deal is in Tennessee, you have to have 30 days written notice. So somebody can come up and say, hey, you got to be out here tomorrow because you didn't pay your rent. They've got to give you 30 days written notice. Number two, they can't just put you out. They have to serve you with a civil warrant for eviction, and then there's a court date on that. So those people could actually sit there until they go to court, and then after court, there's 10 days. That may be where the confusion comes in on 10 days. After they go to court, and then again, the next step would be the landlord has to file one more petition to have the people's, the individuals, their furniture placed in the yard. And then they have 48 hours to get their furniture out of the yard, or it's considered abandoned. So my advice is, if you're a landlord, don't try to do it without some legal help. If you're in a situation, try to get some legal help and tell you what the law is to help guide you through, even if you're confronted and you need to be put, because they can't take advantage. I've had some cases in there where the landlord got mad and he went out there and changed the locks on the place, and then he demanded all of this money before he would let them have their property. And so we've written a letter and we've corrected that. Many times when someone can point out the law, it will resolve that issue.
All right. Got Sheila here. Good evening, Sheila.
Hi, I had a question, and it is about a probate issue.
Okay, go ahead.
Okay. Here's this. My father passed earlier this year, and his half-brother is the administrator of the will. And the issues is that the administrator has taken things from the property. We brought it to the attorney's attention, and understand the attorney is the attorney for the estate, not for us.
Correct.
And he's taken things from the house, and some of the things were left to other individuals.
Yes, ma'am.
So I'm wondering, the administrator is not performing his duty as he should because he's stealing, and then the attorney has turned a deaf ear to us because he will only deal with the administrator.
Yes.
What are the options for us?
Okay, when you're involved in an estate, you should try to employ an attorney to advance your cause. You know, the lawyer's going to say, I don't represent them, I'm not going to get involved. That lawyer can't be a part of fraud if he knew that administrator was trying to defraud the estate. That administrator's in a fiduciary duty. What that means is they're in a position of trust, and they can get in a lot of trouble for trying to get rid of assets that belong to the estate without a proper accounting. So I would hire a lawyer and let the lawyer bring it to the judge's attention. You can file a motion, say we want a full accounting, and we want to know what they did with the property that they removed from the home.
All right. We got Greta here. Hi, Greta.
Hi, I've got two questions on two different subjects. The first is kind of an update of an earlier conversation that I had with both of you.
Yes.
With regard to my having gone to General Sessions Court and gotten a judgment against an attorney who owed me money. And that was part of a larger investigation that I was having the Board of Professional Responsibility do. And the board, after I got the judgment, they sanctioned the attorney, and they're asking him to they'd asked to make restitution to me by a certain date. he failed to do it, and the amount of money that they awarded me was larger than the money that I got requested in court. I didn't even ask for restitution; they just gave it to me. So my question is, I've waited to see what happens next now that he's basically, given the finger to the board, and what I've been told is just to wait because they're going to be looking into it. But what they're able to do is just limited to, I guess, just borrowing him or something at that point.
Yes.
So what I'm wanting to know is, should I wait to hear from them or go back to General Sessions and try to collect, because we're talking about two different amounts of money? That's the first question. The second question is, I'm making a lot of changes now. I'm going to make some changes to my will, and also I'm wanting to create a trust, and so I'm going to be going to an attorney. But what I want to know is, I'm a part owner, a silent owner, I guess you'd say, and in an enterprise that was basically inherited. And whenever you want to make a change, such as selling any percentage of your partnership or whatever, you've got to get the approval of the partners. But as I've read the document, there is no provision for what I want to do, which is basically just, I don't want to sell my portion. All I want to do is move it over to this trust when I create it. So my question is, do I get the signatures first or contact the attorney first? I'm just trying to save some costs in that.
Okay, well, the first thing that I would address is, if you have a civil judgment, that's going to be separate. You already understand those, the civil judgment and then the judgment that they may have regarding sanctioning that lawyer. The civil judgment's what you have the right to pursue. You can issue an asset subpoena through General Sessions, levy garnishments, things of that nature. And you may even want to just talk to a regular collection attorney and let him go ahead and go through his normal process on attempts to collection. And the second question, I can't remember exactly what.
The second question
was the partnership and the trust.
And the trust.
If you're involved in a partnership, it's a lot of gray areas. Normally, you should have a partnership agreement, and that would dictate how the dissolution would take place. However, many partnerships don't. So you either get into a full agreement with the partners, or you file a petition with the court for dissolution and then get court approval. And if you did not want to dissolve it, you could ask the court to allow you to do that, and the court order would order it from that place.
And you would probably need to create the trust first before getting these signatures, I think that she's talking about.
Okay.
All right.
Excellent. Thank you.
Brian. Hi, Brian.
Hey.
Hey, Brian, go ahead.
I was wondering about what's the responsibility as the property owner. I have some property out in the country. It's like a wild animal, like a raccoon or a groundhog or something, bites somebody on my property, but I don't own the animal.
Right.
What's the? I was trying to look through my insurance and stuff like that. I don't think that I would be responsible if it's a wild animal, would I?
No. As a general rule, I think you ought to put some no trespassing signs up that gives you a certain amount of protection. Because if somebody came in on your property, and again, we don't control wild animals, so I think your liability would be very limited in that. How you could take on some liability, if you were feeding the deer and you were feeding the raccoons and you were feeding bear and people came up to watch, then you could have created a public nuisance or a private nuisance, and you could take on some liability from that. It's sad, but everybody that has land, they say, can we just ride our four-wheelers over your land? If you're a landowner, you're taking on some responsibility. And I have a horse farm and we ride horses, and everybody wants my opinion, say, well, Kevin, how can we protect ourselves? And we do waivers, because I do hay rides for churches and all kinds, and did pony rides because and we always want to help the community. Again, you have to use your good judgment. If they ever charge a fee, that makes that enterprise commercial, and you'd have to have commercial insurance. So as a general rule, you have limited liability, but don't create something that you bring people there and then they have an expectation that it would be safe.
Yeah, this seems like it was always that bar question of, David gets a tiger and keeps it in his backyard. What kind of liability does he have?
I had this zebra one time, and they said, well, what did you ever do with it? I was going to breed that zebra and get some zonies. Those are ponies crossbreeding, and zorses crossbreeding with horses.
Kevin, this sounds like it's made up.
Well, it's true. It's true. And in fact, it was kind of crazy. My daughter was she was Miss Tennessee High and went on to Miss America High. And so when we got there, they all said, I know who you are, because she had a picture of it in their book from Tennessee. And they said, "You're Miss Tennessee's daddy." I said, "How'd you know?" They said, "The zebra." I said, "Yeah, that's right." So it's fun.
Well, we've got a lot more questions to answer, so please keep calling that line 737 plus 737 7587, and we'll be back with Kevin Kennedy after this.